Good evening, my dear friends. Today,
Good evening, sir.
today we are going to discuss about the various meetings of the shareholders of the company. Earlier, there used to be three major meetings. One is the statutory meeting, the other one is the annual general meeting, the third one is the extraordinary general meeting, followed by, of course, class meetings. Today, the statutory meeting provision has been dispensed with. So every company must have necessarily one annual general body meeting once in every calendar year. And apart from that, intermediately in between two annual general meetings, any number of meetings can be held for the benefit of the shareholders at the instance of the shareholders or by the directors being, in fact, calling. Directors themselves calling for such meetings. They are called technically extraordinary general meeting. This is how the provisions go on. Well, friends, what is the purpose of these particular meetings of the shareholders? The meetings of the shareholders are meant for understanding what is happening in the institution, review, rectification, then further taking appropriate decisions for furtherance of the objects of the corporate entity. The meetings have to be held for reviewing also, as I told you. At the same time, every year the annual meeting has to be held for reviewing the affairs and statutorily to comply with the requirements that I have already discussed while dealing with the director's position. And then these particular annual meetings, annual general body meetings have to be held for, in fact, electing the directors on retiring by rotation, submitting the annual accounts, declaration of dividend, and so on. So, friends, prima facie, in the meetings, the shareholders will pass appropriate resolutions. It could be ordinary or special. Ordinary is one with passing with simple majority, and a special meeting is one which is passed with 75% of the voting of the members present in the meeting and who are eligible to vote. This is the most important aspect. So, friends, Section 96 of the Companies Act, in fact, deals with this particular subject of annual general body meeting. First, we will deal with the annual general meeting because there is no statutory meeting now. Section 96 deals with the annual general meeting, and every company, whether private or public, other than, of course, a one-man company, one-person company, must in each year hold, year means calendar year, in addition to any other meeting, a general meeting called as annual general meeting, AGM, and shall specify the meeting as such that it is the annual general meeting in the notice calling for that. And there should not be more than 15 months elapsed between the date of one annual general meeting of a company and that of the next. That means there should not be more than 15 months gap. Then, friends, the provision further says that provided that, this is subsection 1, in case of the first annual general meeting, it shall be held within a period of 9 months from the day of closing of the first financial year of the company. And in any other case, within a period of 6 months from the date of closing of financial year. Now it is a common code. The financial year is closed on 31st March of every year. Then provided further that a company holds its first annual general meeting, suppose it is holding its first annual general meeting, then it is not necessary to hold any annual general meeting in the year of its incorporation. That means if the first annual general body meeting is to be held in the next year of incorporation, in the year of incorporation and the next year together, one annual general meeting is enough. And then The registrar of companies may, for any special reason, extend the time, this 6 months, within which any annual general meeting other than the first annual general shall be held by a period not exceeding 3 months. That means ultimately the total final figure comes to 9 months. Then the next question comes, how and when, where the annual general meeting has to be held. Every annual general meeting must be called during business hours, that is 9 to 6 p.m. on any day which is not a national holiday. Not public holiday, national holiday. And it shall be held either in the registered office of the company or at some other place but within the same city, town or village in which the registered office of the company is situated. Then friends, further provision is that the annual general meeting of an unlisted company may be held at any place in India if consent is given in writing or by electronic mode by all the members in advance. That means for unlisted companies, this is a privilege. Then the central government may exempt any company from the provisions of this section, this subsection, subject to such conditions. Then here national holiday means and includes a day declared as national holiday by the central government. August 15, January 26, Mahatma Gandhi, Jayanti. So these are all the national holidays. Then friends, under section 97, if the annual general meeting is not held on time as per the requirement of this particular provision, then the members can give a requisition, members can approach the National Company Law Tribunal, the members can approach the National Company Law Tribunal, and then the National Company Law Tribunal can pass appropriate orders under section 97. It says that if any default is made under this particular section 96, then in holding the annual general body meeting, the tribunal may, notwithstanding anything contained in this act or the articles of the company, on the application of any member, even one member, can call or direct the calling of an AGM and give such ancillary or consequential directions as the tribunal may think fit. Then friends, the directions may include a direction that even one member of the company present in person or in proxy shall be deemed to constitute a meeting of the general body. Then a general meeting held in persons of the subsection 1 shall, subject to any such direction of the tribunal, be deemed to be the annual general meeting of the company under this act. So friends, section 96 has to be read with 97. It can't be studied in isolation. Then, a further question. Section 98. The power of the NCLT, National Company Law Tribunal, to call meetings of members. If for any reason it is impracticable to call a meeting of a company other than an annual general meeting, in any manner in which meetings of the company may be called, or to hold or to conduct the meetings of the company in the manner prescribed by this act or the articles of the company, the tribunal may either suo motu or on the application of any director or member who would be entitled to vote at the meeting, order a meeting of the company to be held and conducted in such manner as the tribunal may direct as it thinks fit, and give such ancillary or consequential directions as the tribunal thinks expedient, including directions modifying or supplementing in relation to the calling, holding and conducting of the meeting, the operation of the provisions of the act or the articles of the company. Provided that such directions may include a direction that even one member of the company can be present and then appear in the meeting, attend the meeting, and then pass appropriate resolutions and vote. And any meeting called, held and conducted in accordance with any order made under this subsection 1 by the NCLT, for all purposes to be deemed to be a meeting of the company duly called. So friends, any meeting also can be held, and then with the instance of the NCLT, or AGM also can be held at the instance of the NCLT. And under section 99, 99, 96, 97, 98 and 99 are very important for AGM, where if any default is made and with the directions or with not holding, then every officer who is in default shall be punishable with fine, which may be extended to 1 lakh, and in the case of continuing default, with a further fine, which may extend to 5,000 rupees for every day during which such default continues. So friends, with this, we conclude our discussion on the annual general meeting. Normally there could be a question on the AGM. These are all the basic, in fact, issues to be discussed in the examination point of view. Now the next question is, what is the extraordinary general body meeting? Whatever meetings are held in between two annual general meetings, those meetings are called extraordinary general body meetings. EGM, extraordinary general meetings. Section 100 deals with this subject matter. Section 100 says the board may, whenever it deems fit, call an extraordinary general meeting of the company, and provided that an extraordinary general meeting other than of the wholly owned subsidiary of a company incorporated outside India shall be held at a place within India. And the board shall, at the requisition made by, in the case of a company having a share capital, such number of members who hold on the date of receipt of requisition not less than 1/10, 10% of the paid up capital of the company, as on that date carries the right of voting. And in case of a company not having a share capital, the number of members who have on the date of receipt of requisition not less than 1/10 of the total voting power of all the members having on the said date right to vote. They can call for extraordinary general meeting. They can give a requisition to the board, and board can call for extraordinary general body meeting within the period specified in subsection 4. There is a more time limit put on this particular board of directors. So the requisition made shall set out the matters for the consideration, and then shall be signed by the requisitioners and sent to the registered office of the company. And then subsection 4 says the board should act within 21 days. And if it does not act within 21 days to call the extraordinary general meeting, then the requisition, and then the question comes that if the board does not within 21 days from the date of receipt of a valid requisition in regard to a matter proceed to call a meeting for the consideration of that matter on a day not later than 45 days from the date of receipt of such requisition. Within 21 days, initiate and hold the meeting within 45 days. The meeting then can be held by the requisition themselves within a period of 3 months from the date of the requisition. 21 days, 45 days, 3 months. A meeting under the subsection 4 by the requisition shall be called and held in the same manner as if it is held by the board of directors. Any reasonable expenses incurred in this particular company shall be reimbursed to the requisition by the company. And the sum so paid shall be deducted from any fees or other remuneration under section 197 payable to such of directors who are in default in calling the meeting. Now friends, a most important thing, section 101 and 102, section 96, 97, 98, 99 annual general body meeting, 100 extraordinary general meeting. I am talking of meetings of the companies. Section 101 speaks of the notice. A general meeting of a company may be called by giving not less than 21 clear days notice, either in writing or through electronic mode, in such manner as may be prescribed. Email is also sufficient. WhatsApp also is sufficient. But notice has to be given. Then provided that a general meeting may be called after giving a shorter notice than that is specified if consent in writing is accorded to, in the case of general meeting, by not less than 95% of the members entitled, and in case of any other meeting, that is extraordinary general meeting, by members of the company holding, if the company has a share capital, majority number of members entitled to vote and who represent not less than 95% of such part of the paid up share capital of the company and gives a right to vote, or having, if the company has no share capital, not less than 95% of total voting power exercisable at that meeting. This is the requisition. So, notice of meeting is a must Audi alteram partem, without notice. In fact, the company, cannot proceed off with holding the meeting thereon. Then every notice of meeting shall specify the date, time, place, and the hour of the meeting, and shall contain the statement of the business to be transacted. And the notice of every meeting shall be given to every member, legal representative of any deceased member, or assign of the insolvent member, auditor, auditors, every director. Then any accidental omission to give notice, or the non-receipt of such notice by any member of other person who is entitled to such notice for any meeting shall not invalidate the proceedings. It could be inadvertently done. Now the question is, what is the business to be transacted in a particular general body meeting? It is extraordinary or in annual general meeting. In every annual general body meeting, the basic items to be transacted necessarily or happen to be: number one, the approval of the annual director's report. Second, appointment of directors who retire by rotation, appointment of auditors, and declaration of dividend. These 4 items are called ordinary business. Any business other than this is called special business. So in the annual general body meeting, any business other than this 4 is called special business, and in extraordinary general meeting, every business is a special business. This is what you have to understand. An item of special business can be passed through an ordinary resolution. There is no problem. It all depends. Companies Act stipulates as to which are the issues to be handled through special resolutions, like the Memorandum of Association, amendment, Articles of Association, amendment, special resolution is required. And the business also is a special business. Now friends, section 102 says, a statement setting out the certain material facts concerning each item of special business has to be transacted, must be given, and annexed to the notice calling for such meeting. That is called statement to be annexed to the notice under section 102. Every special business must be indicated by a statement annexed to the notice. And what is the information? The nature of concern of interest, financial or otherwise, if any, in respect of each item of every director and the manager, key managerial personnel, relatives of the managerial personnel, and any other information and facts that enable members to understand the meaning, scope, and implications of the items of business and to be taken for decision making. And then, in case of annual general meeting, all business to be transacted thereat shall be deemed special, other than, as I have already told you, the consideration of financial statements and the reports of the board of directors and auditors, dividends, appointment of directors in place of those retiring, appointment fixing the remuneration of the auditors, and in case of any other meeting, all business shall be deemed to be special business. This is stated under section 102, subsection 2. Then provided that where any item of special business has to be transacted at a meeting of the company relates to or affects any other company, the extent of shareholding, interest in that other company, or every promoter, director, manager, if any, and of every other key managerial personnel of the first mentioned company shall, if the extent of such shareholding is not less than 2% of paid up share capital of the company, also be set out in the statement. So, section 102, the statement to be annexed for special business is a very crucial statement. Those details have to be given very meticulously. These are all the very important provisions which have to be read with this particular section 102. Then friends, 103 is the quorum. Quorum is the minimum number of shareholders supposed to be present for holding a valid meeting. And quorum for holding a class is 1 student. So, a quorum for holding a meeting, a private company, public company, one-man company is 1. And it is in case of articles, in fact, may stipulate otherwise a larger number, but not lesser number. Otherwise, in case of a public company, 5 members personally present if the number of members on the date of meeting is not more than 1,000, and 15 members personally present if the number of members as on that day is more than 1,000 but up to 5,000, and 30 members personally present if the number of members as on the day of the meeting exceeds 5,000. Otherwise, the meeting is invalid. In the case of private company, 2 members present personally shall be the quorum for a meeting of the company. Then if the quorum is present within half an hour, is not present within half an hour from time appointed, the meeting will stand automatically adjourned to the same day in the next at the same time and place, or to such other date or such other time and place as the board may determine subsequently. Or the meeting, if called by requisitions under section 100, shall stand cancelled because there is no quorum. Provided that in case of an adjourned meeting or change of date, time, place, so and so, the company shall give not less than 3 days notice to the members, either individually or publishing in any advertisement in newspapers, vernacular, one English, one vernacular, and which is in circulation at the place where the registered office of the company is situated. If the adopted meeting also the quorum is not present within half an hour from the appointed time, the members present shall be the quorum automatically. Even one member present shall form the quorum thereon. Then under section 104, for every meeting a chairman has to be elected. If there is a chairman, fine. Otherwise, a chairman has to be elected. And then section 105 deal with proxies. And then the voting pattern is given under 106, 107, 108, and demand for poll under 109, where the democratic process is followed thereon. Postal ballot under 110 and circulation of members resolution under 111. And then most important for government companies, section 112, where there is the President of India or the Governor of a state happen to be the member of a company officially and appoint is such person. If he is a member of a company, then he may appoint such person as things will act on his representative at any meeting of company or meetings of any class of members. A person so appointed shall, for the purpose of the be deemed to be a member and shall be entitled to exercise the same rights, powers, and as if the governor or president would be personally present. And then, friends, now section 114 deals with the resolutions. And then resolution says, a resolution shall be ordinary resolution, which I have already explained to you, which has been duly given and is required to be passed by votes, whether by show of hands or electronically or in poll, where in fact, if it is passed with simple majority. And a resolution is a special resolution, where the intention to propose the resolution has been duly specified. I have already told you. The notice required has been given, and the votes in favor, so and so, by whatever means, is not less than 3 times the members of the vote, that is 3/4. And then under 115, the resolutions require special notice, whereby any provision contained in the article, special notice is required of any resolution. Notice of the intention to move such a resolution shall be given to the company by such number of members holding not less than 1% of total voting power, or in holding shares together or individually, or in fact shares not exceeding value 5 lakh rupees as may prescribed and has been paid up, and the company shall give its members notice of resolution in such manner as may be prescribed under the rules. So friends, these are all the general procedure to be taken at the meeting, and all the meeting proceedings to be minuted and then recorded, that is called minutes under section 118 of the Act. Section 118, please go through it, tells you how to maintain the minutes book, and then how to take care of, and then how to sign by the chairman, and all other details thereon. And this particular chapter is concerned, this does not apply to one-person companies. So my dear friends, with this background, we conclude our discussion on the general meetings of the shareholders of the company, and I have already dealt with the meetings of directors earlier, and I told you there should not be, there should be compulsorily meetings of directors once in every 3 months, and that particular aspect has been already covered elaboratively. So with this we conclude another important topic, that is meetings of the shareholders of the company, and other topics slowly we will study before 8th August. I will try to complete the syllabus. Thank you very much and good night. Bye-bye.